Hello and welcome. Good afternoon, everybody.
Good afternoon.
Welcome, everyone. A fantastic session for you today. Firstly, we'd like to put out a huge thank you to Eddie for helping us to assemble this panel on which a genuinely hot topic in the market, not just for Sydney, right across Australia. We're all interested in this discussion, aren't we, about what is the market doing and are there opportunities, which we believe you're going to find today's session quite encouraging in that regard. We'll just give another 30 seconds just to make sure those people coming through the waiting room have been able to do so. Of course, for our panel, I'd like to welcome Eddie himself, Bakous, Joe and George. And we've got some great content for you all today. A bit of housekeeping. What we will do is we will mute all of the broadcast, just allowing the panelists to obviously unmute, and that will keep the audio more consistent for everybody. When your microphone's permanently unmuted, any background noise can disrupt the Zoom video broadcasting software. So please bear with us in that regard. Obviously, the panelists will, of course, be unmuted as they come on and share, and we do have a lot to cover. So let's get going. And firstly, we're going into our slide presentation today here. Okay, and here we go. So just some housekeeping to get us going. The microphones will be off in the main session and the panel will be contributing all the way through the main session. Please note, we are going to have 10 minutes of Q&A at the end, and that will be a fantastic time to ask questions that come up for you during the session. If you have questions along the way, please use the chat feature. And what we will do, just to make sure you, if you're not too familiar with the chat feature, I've just sent you a test. Everyone should have just received a test chat. So would you, if you want to kindly, get a bit comfortable with and familiar, jump on your keyboard there. G'day, Sam. Sam says hello. Perfect, Sam, that's the way. Hello, Wid. Hi. That's it. Perfect, Wid. Emily. There's Emily from our team and Ari. Excellent, Ari. G'day, Ari. Hello, Ruth. Terrific. That's what it's all about. So let's get on there and chat. And if you've got comments or questions along the way to do with the content, please do. Yasmin. G'day, Yasmin. G'day, Morris. G'day, Gihad. Peter. Nice to see you, Pete. Tony. Joe, so make sure, that's fantastic. Make sure you are chatting with us along the way if there's a topic of particular interest, because we are recording this session and we have a couple of bonuses for you for attending today, as well as the recording at the very end, let alone direct access to our panel. G'day, Andrew. Nice to see you. Tony, Joseph, fantastic. That's great. So you've got that chat box familiarity. That's what we wanted to see. Terrific. All right. So there'll be a formal Q&A at the end, but please do use the chat feature along the way. Please share with us your comments and issues along the way. Emily and the whole panel will be keeping an eye on that. All right, terrific. Okay, now let's have a look. There is a general advice warning, very, very important, as you can imagine. The information contained in today's presentation has been prepared as general advice only, and it does not take into account your personal or investment objectives or your financial situation and particular needs. The presentation is certainly not intended to represent or be a substitute for legal, financial or investment advice, and that should not be relied upon as such. You should consider whether this information is appropriate to your situation, and where appropriate, make sure you're seeking professional advice from people like Eddie as a lawyer or from financial advisors before making any decisions. All assumptions and examples are based on current laws and the continuance of these laws and our interpretation of them. So we do not undertake to notify its recipients of changes in the law. So we can't do that. And all examples are for illustration purposes only and may not apply to your circumstances. So please do keep that in mind. Of course, I'm John, and the really, really dynamic, entrepreneurial, handsome character on the left is Eddie, based in Western Sydney, of course. And of course, here's our fantastic guest panelists here. We've got Joe, Bakous and George, and they've got, along with Eddie, they've got so much to share on this current market and what's going on, with some absolute gems and opportunities for those budding developers and property entrepreneurs. You're going to be really excited with some of the gems that these guys have come up with today. Here's our agenda on the screen. I won't stick around on that. We want to get straight into it. So without further delay, let's do that. We have a poll, okay? And Lauren is going to help us. Maybe Lauren, jump in now and unmute and just remind. There we go. Who are you today, ladies and gentlemen? Are you a property developer? Are you an investor? Do you represent, or are you interested in a syndicate? Because you might not be in one, but maybe you'd love to get into a property syndicate where you've got access to opportunities. And what about the other? Mind you, if you feel like after I said that, you'd love to be in a syndicate and you've already answered the poll, you can always reach out in the chat box, can't you? And say, hey, yeah, let us know about those things. Certainly, there are some interesting movers and shakers in the market in syndication, that's for sure. Okay, great to see the poll coming through, and we've still got people coming through into this session as we speak now. So our team will continue to allow people through the waiting room. Okay, we've got 32 of 33. That's great. We're nearly there. 60% of you have voted. Hopefully we'll get that as close to 100% as possible with the vote, just so that we understand and we can really tailor some of the content, particularly from, say, Bakous and Joe and Eddie and George as well. Today uniquely for you people, the audience. Okay, so fantastic. All right, that's a pretty good catchment, isn't it? Let's keep moving, shall we? Thank you everyone for sharing in the poll. We really appreciate that. Okay, great stuff. All right, let's keep moving. Thank you, Lauren. Nice job. All right, the property market has changed, hasn't it? The property market has changed. We're going to get Eddie to introduce some of these key concepts here. So Eddie, when you're ready, what are the big insights that you've got here from these bullet points? A lot of turmoil, a lot of uncertainty. Over to you, mate. Just get you to unmute.
Sorry, thanks, John. Thanks for the introduction. I don't know about the good-looking side of things, but yeah, we appreciate that. COVID-19 obviously has been a major topic of discussion for the past 6 months. We all seen that there's been issues around the market with what's going on. Today, we want to obviously focus on in relation to what impact, if any, the pandemic has had on the property market. I will be asking the panel throughout this talk to input their ideas into this as well. But firstly, I'd like to obviously thank yourself, John, for the opportunity to be here as well. Also, Joe El-Sabbagh, one of our architects and the chairman of the Greater West Architects Network, Bakous as well, of Makari and Co, and George Karam of BF Money. All these boys have got great insight and great intelligence in this area as well. Look, without a doubt, the property market across Australia has taken a hit. Sydney, experts have said, has been the hardest hit. It's obviously there was drops in values in suburbs across Sydney. Not every area has been affected significantly, and those areas have kept the property market alive at this stage based on experts' reports. Look, I believe personally that the market has come down due to a loss of consumer confidence in the market. There are buyers still out there looking for a bargain. So of course, it's important for developers and investors to consider their sale prices as well in this market at the moment. But property experts have will believe that the downturn in the property market is going to be determined by the length of the lockdown of this coronavirus pandemic, and also the level of unemployment and the lack of consumer confidence. I personally believe that the virus has had an impact in relation to how properties are being sold across Sydney, and probably across Australia in its entirety. It's more than likely that the preferred method of sale today is by private treaty rather than auctions. However, the latest auction clearance rates have indicated that there's been about a 68% sales of properties listed by auction over the last weekend. So that's a good sign of an increase there. You all would probably know that banks have actually toughened up their lending criteria as well during this COVID pandemic. Valuations are going to be a big impact for purchasers. And these are things that you guys would need to take into consideration. What does it all mean to developers and investors? I'm going to get an input shortly from the panel about that, but just my personal belief on this is, firstly, you're going to need to do appropriate research in the particular areas you wish to purchase. Banks, as you are probably aware, if you're an experienced developer or investor, they are definitely watching where they're actually lending funds to in particular areas. We have had situations where clients have actually jumped the gun, exchanged contracts without properly obtaining or speaking to their financial institution in relation to whether they can actually get funding there. And of course, their bankers have told them, no, we're not lending in that particular suburb. So I would highly recommend that you actually contact your broker regarding that. Secondly, you'd need to really look at your buyer market. You know, who is your target market? The first home buyer at the moment is receiving a number of fantastic grants, and there are people that I believe developers should be targeting at the moment, especially up to a market of 800,000. We will discuss first home owner grants a little later in this presentation though. And thirdly, I also believe that you need to set your sale price right. You know, you've got to be realistic about that price. There's no point putting something high and getting a buyer. Everyone wants to buy a property. The problem you have is that you will have a financier who comes along with a valuer. And of course, they're not going to set that price. So you really need to sit down with your agents and price it right.
Well done. And just about the fundamentals, mate. Are you happy to move on to those now, or is there a couple more tips there?
No, absolutely happy to go on with that, so we don't speed up a bit. I've always believed that in property, these are the fundamental drivers of the property. Population growth. I mean, Australia's population is growing by 300,000 plus a year. So these people are going to need accommodation. Immigration. I know the borders are currently closed, but once they do open, the Australian government, we're going to end up, that population is going to grow again. Interest rates are currently at all-time lows. It's very attractive for purchasers at the moment, so we'll boost the property market. The economy, we know the Australian government is boosting billions of dollars into supporting businesses at the moment. Of course, employment and number of building approvals will also determine the property market. And also don't forget the first home buyers are back in the market as well at the moment. Look, the pandemic is temporary. I believe that, you know, we all know that history has shown us that the property market will always bounce back. And you should definitely do your homework in certain areas where you're looking at purchasing. Speak to your agents, speak to your lawyers, speak to your accountants and get some assistance. But definitely in this market, you should definitely speak to your financiers or your brokers in relation to any facilities that you're looking at. At this point, I'd really like to ask the panel about what their inputs are in relation to the property market and where they see it going in the future.
Thanks, Eddie. Well done. In terms of the essential strategies that we've identified here, what are the real issues for somebody prior to purchasing a site? Because you've seen a lot of things go wrong through a bit of optimism and naivety in the past, right?
Yes, John. Unfortunately, it's a very common mistake for a first-time developer or investor not to do their homework up front. I believe that there's certain factors you need to take into consideration when you're purchasing a development site or even a property, is that you probably do, and I've listed some of them there down there under risk for developers. I believe you should really have a detailed feasibility created up front. You should be aiming for a 20% profit margin on your project. Your bank generally would be requesting that. If you don't know how to do one, you should definitely, ask your consultants for some assistance. But a proper feasibility is very important so you don't sell yourself short throughout your project or even at the tail end of your project. The next thing I think you should be considering is also making sure that you've structured your purchasing entity right. This is a big problem if you don't. We've had situations where clients have actually structured themselves, be it in a syndicate or a joint venture process, where at the end of the project, they have been lumbered with massive stamp duty obligations to try and petition those units away into their own individual names. And also, it's a benefit of the structuring up front as well is for asset protection and for tax minimisation as well. And I think Bakous will be talking about that a little bit later on. So also I highly recommend that anyone speak to their financial institution or broker to look at their loans. We've had situations where builders have actually come or developers have come through to our office, exchanged contracts as I indicated before. Unfortunately, the bank didn't lend them the money. So it's very important that you do your approvals prior to exchanging any contracts at all. The next thing I would like you to consider as well is your buyers and off the plans. Most banks are going to require pre-sales. George will probably talk a bit more about that a little later on in the presentation. But what happens if you don't have any buyers? You really got to look at your reduction in your purchase price or coming up with some sort of incentives for purchasers, especially like first home buyers who are currently out in the market. You will see some big developers targeting those first home buyers. It's something that you should maybe follow the call on that. If you can't sell them, you need to give thought as well to holding costs, because you may want to keep them. Will the rent cover the holding costs that you have there as well? So you should incorporate that into a feasibility that you will do at the beginning of the project. But I always believe that the most important thing for most developers or builders is to make sure you get your building contracts right up front. If you don't do that, you're actually going to find yourself in a situation where you could end up in an unnecessary litigation. And then you'll be sending people like myself or any of your lawyers through to a European holiday. So we don't want you to do that. But overall, if you do get stuck, be in regular contact with your consultants and advisors and your agents. You're paying them, your lawyers, your accountants, you're paying them for their services. So use them. That's the whole purpose of it. They should be on your phone speed dial. They hurt more than your dentist if you don't get it right. So make sure you actually get in touch with them if you find that you're struggling with anything as well. As I mentioned earlier, though, the purchasing entity is a crucial thing. Make sure you've actually looked into your structure. It's very, very important for your asset protection and for your tax minimisation. But of course, like I said, it's going to give you a benefit at the end of the day. But to talk about that, I suppose Bakous will be talking about that in the next slide. So I might hand over to him.
Thanks, Eddie. Yeah, just introducing Bakous, 25 years of experience, CPA, Director of Makari and Associates. Bakous, over to you, mate. What's the important issue about Australians and their exposure with asset protection? Let's get you to unmute there. Just
unmute.
There you go. Thank you.
Oh, thank you, John. Well, first and foremost, one must look at the considerations due to COVID-19 and other considerations pre-COVID-19, and that's asset protection. Pretty much that's part of the structure and how you undertake a property development, because let's face it, property development is a high risk game, high return, but there's ways to prevent having to risk losing certain assets. And some of the issues I see with property developers, which Eddie touched down on, is the feasibility studies. There's been countless times when clients come and see me and they have a large project to undertake, that certain factors haven't been taken into account, say the GST on the sale of the units. That could cost an extra 7 or 10%. The fact that the holding costs may accumulate due to inability to be able to sell stock in this current market. I think the developers will have problems selling due to the fact that the market's changed and people are reluctant to go out and and buy stock when there's so much stock. So you need to factor in, first and foremost, what is it going to cost me? What's the worst case scenario? As Eddie touched on it, a minimum of 20% return, and cover all the different types of risks. Have in place proper contracts. So if you're a developer and you outsource the construction to a development company, make sure the proper clauses in there for the additional costs if it overruns, and make sure you have the proper insurances in place. There's been countless situations where workers' comp is missed, and if an employee on a site gets severely injured, or a contractor who's killed or hurt, that could be the end of that project. The ongoing holding costs in relation to the property. What a lot of developers fail to realise is the ATO have an eye on what they call Division 129 Act, which specifically says that if you're a developer, your intention is to buy, build and sell at a profit. Let's say you build 100 units and you've sold 60 units off the plan, there's 40 units remaining. Now, if the developer starts to rent those properties, automatically they fall under that Division 129 provision, which effectively means that they have to pay back the GST on the construction cost over a period of time. So if the developer hasn't factored in that in their feasibility, that could be a major issue. And with the new law provisions governing directors from 1st of April, developers may be liable there as an individual director for the GST that's unpaid. So considering all of that, what's very crucial is so many developers continue to undertake a project, move on the first project, they keep quite a large chunk of stock or property holdings in that structure, and then do the next development and next development. But what happens is they're exposing the previous assets or the unsold stock to a new development risk. So it's very important to try and isolate that risk by setting up a different structure that undertakes that development, because last thing you want is to have a major risk in one development where the development could fall over, there's a major injury, the bank's calling on the loan, and you can't sell stock. You might have sold stock a year ago off the plan, but the banks aren't approving the purchasers buying the units because the valuations aren't applicable because at that time. So there could be all sorts of risks. And I also caution, say, mum and dad investors who for the first time become developers, where they might have their own principal place of residence or investment property, which then becomes rezoned into a development. And they undertake a development, whether with a developer, whether they undertake some joint venture agreements, and effectively they've exposed their principal place of residence. There's certain ways to try and de-risk that development so that effectively you're not going to lose your house, especially for newcomers, but having potentially a special purpose vehicle is crucial. So speaking to your accountant or your lawyer to make sure that documentation is in place, to have the proper contracts in place, make sure you cover all the provisions, any clauses, whether you have a builder in place, make sure you have a proper building contract. Everyone knows their responsibilities. And of course, it's crucial to make sure that you understand the finance involved, whether you can actually obtain finance for that development. It's no point taking an option on a project where you know down the track that either one, that the council may not allow for the DA, and you possibly not be able to obtain finance, especially during this period of time with COVID-19. Again, don't put all your eggs in one basket. Use separate entities, use joint venture agreements, special purpose vehicles, which separate the risks from the ownership. It's just like running a business. Do you put all your assets in that business? So if you're a construction company or a developer and you have large amount of assets like machinery and equipment, and other assets like properties and cash, keep those in a separate vehicle, and you can always pay a lease fee or a rental fee. So that way there's a deduction in that entity. But have the proper structures in place. Not all structures are the best structures, but moving forward, for example, sole traders and partnerships, there's some of the, on the next slide, I think we may cover that, where there's a joint and several liability. If you're in partnership with someone in the development, there's always those sort of developments. But another factor is insurance. Basic concept of asset protection. If you're sick, what happens? Who's going to take over running of the business or the development? Do you have any income protection, or do you have any trauma cover? Make sure you have your public liability in place. Workers' comp insurance for your employees working on site. Someone gets hurt, you know, who's going to be liable? Do you want to end up in the next few years in litigation? You know, landlord cover. The basic first thing is make sure you get all your insurances in place. So there's some form of element there. So you're de-risking the overall project. Coming back to the structures, I'm not a big fan of partnerships because there's a joint and several liability, unless it's in a form of having discretionary trust in partnership. But and sole traders, there's always that risk. But you can avoid having to transfer property to a structure to minimise the risk and incurring capital gains tax and stamp duty. There's certain ways to do these things where you're not up for all these additional costs. Certain developments would probably be a good idea having them in a company structure where you pay a flat rate of 27.5 cents on a dollar. But depending on whether you fall under a capital gains strategy scenario, but most developers will fall under a profit-making intention or carrying on a business, or under the trading stock provisions. I like the discretionary trust structures. In particular, I see the unit trust structures quite useful for investors getting together and undertaking a project where they pool the funds of money in there. Each one has a fixed interest in that unit trust, so we know at the end of the day who gets what percentage of the project. Self-managed super funds are also a good vehicle. They're actually allowed under the SIS Act to develop properties, but one's got to be very careful because the laws are quite stringent there, and if you fall foul of the super tax laws, the fund can be non-compliant. But you know, there's a 15% tax in that super fund. If it's a pension within the self-managed super fund, there's zero tax because the fund it falls in the pension. You can pull other members up to 4 members. There's some control in the super fund there, but you just got to be very vigilant in undertaking any self-managed super fund developments. You got to have dot the I's, cross the T's, have the proper documentation. Borrowing through self-managed super funds must be via limited recourse borrowing arrangement. Must tick all the boxes in relation to the compliance with both the banks and the ATO. So what are the benefits of structuring? Obviously, you work all your life for many years. The last thing you want to do is lose your hard-earned work by losing your assets, such as your family home, which does happen quite often, especially for those who start in a new development and don't realise all the risks where they haven't factored in certain additional costs going into developments with builders who might not be as credible. And other benefits like structuring through succession planning, having a bloodline trust or testamentary trust, passing on the assets to your children, knowing that your children will inherit those assets over the long term. They're crucial, and having to not have to incur capital gains and stamp duty in transferring assets to the family structure. Certain structures allow for legally minimising tax through potentially discretionary trusts, to streaming to family members, low-income beneficiaries via using a trust resolution at the year end. Also obtaining capital gains concessions. They're not normally available for companies, but having potential discounts for small business concessions and capital gains concessions can make a big difference in relation to how much tax you pay. Potentially having a bucket company that pays 30 cents on a dollar rather than 47 cents on a dollar, and getting that all intact. But you need to plan first what you're going to do step by step, beginning with the feasibility, the cost, knowing whether you can get the finance, looking at the tax implications, and protecting the asset, which I think is quite crucial. Some of the golden rules of wealth preservation, as we said, holding assets in separate entities from the at-risk construction or at-risk business entity is a very crucial element. There was a case, Cummings QC case, where this barrister hadn't lodged his tax return for over 15 years and he thought he'd get away with having to pay income tax. Little did he know that ATO had different ideas, and this case went to the High Court. And at that time, he argued that the fact that he didn't have any creditors or money owing, but the ATO said otherwise. They said, well, you had a contingent liability because you haven't lodged your tax returns for over 15 years. And he thought he'd be smart by transferring the property he had into his wife's name. So the bankruptcy trustee was successful in the High Court and overturned that transaction in a form he tried to defeat creditors. There's no point doing certain things like acts of bankruptcy or trading whilst insolvent, because sections 120 to 122 of the Bankruptcy Act have clawback provisions, and whether you have creditors pending, whether you try to defeat creditors, could be a 2.5-year period or 5-year period where they can come back and claw back any changes or unwind any different structures. So you're best planning ahead, not, as you say, like the house was burning and you want to try and change these different structures and prevent the risk. And setting up protective firewalls, as I said, setting up different trust structures. You might be a professional with a high risk category. You might look at considering owning the shares in the company through another trust rather than as an individual, because bankruptcy trustee can access those shares, even though they might not be worth much, but they can have control over your holding company. Little basic things like having the company as trustee for a trust rather than you as an individual. You want to prevent that sort of risk, and trying to take shortcuts with paying some money up front to get the right advice can cost you a lot of money. I've seen it a vast amount of times where people sort of try to avoid having to incur the cost up front to get the right structure and get the right advice. But when the trouble starts to arise, it could cost them a fortune. And there's no turning back in relation to some of these litigation matters. Some of the property taxes, the most obvious is the trading stock provisions for developers, those who continue to develop, and that's their line of business. Then they fall under trading stock provisions, which effectively means the cost incurred in purchasing the land and the construction are deferred to the end of the project, where you offset those losses against the sales. The next tax is the profit-making intention. That's effectively if you're carrying on the business. However, the difference is that the deductions and the cost incurred on the project can be offset against other assessable income. Capital gains doesn't normally apply to developers. However, as I said before, if you're a first-time developer and you're building, say, a duplex or a few units, or it's your home that's been rezoned, and it's what they call mere realisation of asset, then you could be entitled to capital gains concessions if the property is held for 12 months or more. But that's not available in general for companies. So getting the structure right is very crucial. So moving on, GST is, I think, is quite a complex tax for many. It's now 20 years in the making. When John Howard introduced GST back in July 2000. Very important, speak to your lawyer, get the advice before you enter into a contract. Have a look at whether the contract stipulates it's GST inclusive or exclusive. There's many case laws in the court to argue whether at an auction, you know, when the hammer ends, is it including GST or excluding GST? So there's many case laws in relation to that. So make sure the documentation is correct. Speak to your lawyer so you know whether you're paying GST or not. But very, very important, the other one underestimated is the margin scheme. The margin scheme could help reduce quite a bit of tax in relation to GST. Normally GST is 10%, but you may pay 7% under the margin scheme. But again, you need to satisfy certain rules and criteria which the ATO hold that must be in the contract, must be stipulated before you sign that contract. Again, be careful of Division 129. Developer builds 100 units, keeps 50, and decides to rent those units because he can't afford to sell them at potentially a loss or reduced value, or the banks aren't allowing the purchasers to go ahead because the valuations have dropped since the off-the-plan sales. So the ATO want you to pay back the GST on those construction for those 50 units remaining, and that could be quite a lot of money. So that will have to be paid back over a period of time. So you don't want to be stuck in that situation, because the intention is to make a profit. The ATO says, well, the credible purpose of that project has changed. You now become an investor. So if you're an investor, you need to pay back the GST on the construction. So that's a very important part of the legislation, which is quite specific to developers. The 5-year rule exception as well. Again, if you're a developer and you hold stock and you've held that stock, the remaining stock that you can't sell for 5 years or more, you may be exempt from paying GST on that stock because they're no longer classified as newly built properties. However, you've got to pay back the GST on the construction per Division 129. And under the new rules, the purchasers must remit the GST to the ATO for newly built properties, so that the ATO are aware of developers and those out there not paying their share of the GST. Very important, the company director liability rules now. There's from 1st of April 2020, company directors can be held personally liable for unpaid GST, unpaid luxury car tax, and the wine equalisation tax. At the moment, if you don't pay your super for your employees or the withholding tax obligations, you'll be personally liable as a director. But 1st of April, you can be personally liable for GST that's unpaid. And in conjunction with that, ASIC, the ATO saying you can't go back and backdate resignation of directorships or leave the company without any directors. You'll still be liable. But what happens next is if you are subject to, what are your defences if you are subject to these new rules to prevent what they call phoenixing of schemes, where it's been in the media where several developers will close up their company, not pay their workers' comp, not pay the superannuation, get away with paying income tax and GST. So the ATO are quite concerned with that, and they're trying their best to prevent that. And in a sense, it's unfair for those who do the right thing to pay their share of tax, and others who don't, and it has an impact on the end revenue to the government. The next slide, the 21-day rule. if you do get issued a director penalty notice, there are some defences in relation to into relation to this liability, that you may be personally liable, where you're a common director with another director in a company, where you don't have any day-to-day management of the company. Effectively, you're just sitting there as a dummy director. But you know, it's difficult to convince the tax office that you had no interest in the company, that you didn't take all reasonable steps to pay the debt. So if you're a director, you know, you have obligations under the Corporations Act. You must comply. You must do what's right. Otherwise, don't be a director. Again, I always suggest that if there's a mum and dad going into a development first time, have one director. Why have two directors? You may have to then offer personal guarantees to the banks. Why expose yourself? Look at who owns the assets. De-risk that exposure. So they're basic things that you need to do. Get the advice. If you do get issued with those director penalty notices, don't sit on them, because after 21 days you will be personally liable. You have the bankruptcy trustee chasing you, and get the right advice. Seek advice from a lawyer and accountant, and prevent the future headaches and litigation that you can end up using courts. There's countless case law on these situations.
Thanks, Bakous. Okay, just introducing Joe now. Very experienced character in his field, Joe. Director of Design Corp Architects. It's got some great golden nuggets for the budding entrepreneurs and developers today. History of working in the architecture and planning industry, long-standing career there. Welcome, Joe, and please, let's kick off. Let's get you to unmute there, mate.
Unmute, there you go. Thanks, John. Thanks, everyone, for attending. Look, I thought I'll touch base in regards to some of the strategies I think that have come through on board, and that from our point of view have actually seen that has built a little bit of confidence, especially with what's happening with COVID-19. Now, 2019 was already tough enough for the building industry. We've seen a massive drop in projects coming through, whether being mums and dads, small-time developers, or even the larger developers. So it's been, there was already this massive downturn. Come January, February, we've seen a little bit of a light, and then COVID hit, and then we've just basically seen a lot of people, as Eddie mentioned earlier, that they've lost this confidence in the market. Now, funny enough, the government had been working on a specific code, which is a compliant development code that allows things that never happened in the past, like duplexes, a new term for manor housing, which is a four-unit development, and terrace developments or terrace housing, to actually come in and be dealt with a private certifier approval rather than actually going through council. Now, that came on the 1st of July and it became active. Whilst the government had been working on it for a couple of years, it kept getting deferred. But the 1st of July came, and then actually this code has become active. And what we've seen is that it's actually created this confidence that the market was lacking. And why do you ask why is that? It's because it's removing a huge amount of time, uncertain time. When you submit a DA, as an architect, I can say, look, I guarantee you that I will submit your DA within 12 weeks, 6 weeks, 8 weeks, wherever it may be. But one thing I can't guarantee is how long is that DA going to sit on somebody's desk in the council, because I can't control what they do in council. We can push them, that's for sure, but we can't control the timing. Now, this code, because it's driven by privatization, where a certifier colleague, and I see one of the actual audience is a colleague of mine that is a certifier, would actually have similar timeframes to, they want this project to be on their desk and out, because they want to see, obviously every business wants to see the money rolling in and cash flow. The more work you do, the more cash flow you have for your business, and that helps. So basically what happens then is that you actually, everybody then becomes accountable for this timing, and the project overall becomes more feasible to actually build, because your holding costs are being minimized, because there's a guarantee of approval if you follow the right steps. John, can I go to the next slide, please? So what I've done, oh, maybe the next one, that's a typical example of what you'd see for a duplex. Now, what I did is I concentrated on 3 things that actually this compliant development code is currently doing. I've given this particular example for the developers out there. It just shows an example of a typical block of land in the Parramatta LGA under the City of Parramatta on how you'd actually, what you'd get as a Parramatta controlled DCP if a duplex is allowed in the area. So a minimum sale area under Parramatta control would be 600 square meters. A general rule of thumb is floor space ratio is a must comply, that you need to actually get 50% of your land. 50% of the land means 300 square meters. And then each unit would be around the 150 floor area. Now, if you look at the top part of the screen, under the compliant development code, the comparables there is that you get over 200 square meters more in floor space ratio. So not only you're actually cutting the time frame of getting an application passed through council because you're going to a private certifier. Well, a lot of councils actually have the right to also approve those CDCs. So you don't actually have to go to a private certifier. But so the point I'm trying to make is not only you're actually cutting the costs of the holding costs, you're actually also getting a lot more bigger footprint to those properties. So when you compare the two, you got 78 square meters on the ground floor, but you got 107 square meters on the ground floor under. So this is going to actually create a lot more confidence that, look, I'm getting, my duplexes are no longer sort of these tiny dog boxes, but they're actually growing in size. So it opens up a completely different sort of method of thinking to those people that think, I don't want to live in a duplex, I want my own home. Well, that duplex becomes like your own home because it's a lot bigger than a normal house. Another point, another one of the sort of a newer product that's actually now coming into effect is, can I go to the next slide, please, John? And I specifically picked sort of the R2 and the R3 kind of zoning, which is the lower density project. This is what this falls under. This is a typical example on what you'd get in sort of multi-unit terrace housing under a normal development application. So you see I've done 2 there on a standard sort of block of land. And then on the right-hand side, it took 11 months to get approved. On the left-hand side, it took 9 months to get approved for the same developer. And we did them as separate because in his eyes, we're going to stage them. Now, you could just imagine the holding costs on something like this. Under a CDC or under this new compliant development, the approval process is a lot quicker. So you don't actually need to wait those 11 months and 9 months that I'm talking about. Can we go to the next, John, please? Now, this is a typical example of a corner block. This corner block is actually in Fairfield. We're currently working on this specific one. Can we go back, John? Just to give you an indication. An R3, normal R3 zone block under council regulation, because it didn't meet the frontage requirements, we couldn't actually get a townhouse development in it. Under the current medium density controls, we managed to get 4 townhouses on it. So there's what I call a lot of leftover blocks in many council areas that you can't develop them because they've been landlocked, or you've never been able to purchase next door. You don't meet the minimum requirements and so on. Like there are going to, this is going to create a massive opportunity for these smaller type developers to actually say, you know what, I can do this. It's a lot quicker. Financing is going to be a lot quicker to get through. Application process is a lot quicker. Now, the nicest product that I believe is out there, which is the next one. That's a new term called manor houses. Now, this is, again, we've just, I know it's only been 1st of July, but we've been preparing for this for 2 years. So, we've basically really excited as a firm because, again, we get frustrated with these timeframes. A manor house is typically, the typical requirement for a manor house is as long as you have a 15-meter frontage and you're in an R3 zone that allows multi-unit housing, and you're above 600 square meters, you'll be able to propose a manor home under a CDC code, okay? Those manor homes could be, like this particular one is 3. We've done others, which is on a smaller block of land, which is, on a larger block of land, which is 4. You're not allowed to have more than 4, no matter what size your land is. But what I'm trying to indicate here is that these are 75 square meter units that are on top of each other. Okay, so you're talking. This is the actual floor plate of those. You're talking about within a month and a half, 2 months of me submitting this application to the actual. Can we go back, John, to the? Sorry, you've gone one ahead. Yeah, from us submitting it. That's it. From us submitting it to a private certifier, that you can have a developer breaking soil if their finance is ready within I'd say 3 months from purchasing the land. So, when we talk about negotiating deals and negotiating the contracts, if a client comes to us and say, look, try to get a little bit of a delayed settlement, 3 to 4 months delayed settlement. So you're minimizing your holding cost. As long as you get an owner's consent from the current the owners, what we can do is submit this to the private certifier. They approve it in time. The day you settle, you've booked your demolishers and you're actually breaking soil. This is what this code is going to bring to the market. And this is what we're seeing since the 1st of July, that there is that little bit of light at the end of the tunnel and thankfully the government, again, I don't think they meant to do this. They didn't really mean to do this, but actually it happened. It happened at it's just one of those things that we've been waiting long enough for it. And then we're seeing that sort of, momentum building and the confidence back in those sort of smaller developers. I think I've covered pretty much everything from my end.
Yeah, thanks. Well done, mate.
No problems.
All right, Eddie. Is that unmuting for you? Try that again now. There you
Okay.
go.
Thanks. Am I off? I am. Okay. Thanks, Joan Bakous. That was good information there. Just going to give a quick update in relation to the latest updates in relation to stamp duty and land tax. And we'll get into some first home buyers grants, which I've been talking about previously. But just quickly, in relation to discretionary trusts, and in particular any trusts, but especially discretionary trust, Bakous was touching on this as being a good structure to purchase on. There was an amendment in relation to state revenue legislation this year, back in June, which is requiring all trusts to include or to amend their trusts to exclude foreign beneficiaries. If you do not do that by 31 December this year, you will be held to be a foreign trust, and you will also have you'll also be liable to pay an additional surcharge or surcharges of purchaser duty of 8% and also land tax of 2%. You must make sure you do it. I don't know if all of you out there have utilised trusts, but if it is an older trust that currently owns property or is looking at purchasing property, you must make sure you have that exclusion in there. So please make sure you contact your lawyers or your accountants to actually update those trusts. Just going straight into first home buyer grants. I've touched on these before earlier today. There are several grants available to first home buyers offered by both the New South Wales government and the federal government. Just as a quick outlook, to be eligible as a first home buyer, that you need to obviously be over 18, be an Australian citizen or a permanent resident, but you also got to not have owned yourself or your spouse, if you're married, not owned a property in Australia before, and you must move into the property within 12 months of a settlement and live there for at least 6 months. But just looking quickly at the grants that are available, they are up on the screen. But just as a quick touch over, there is the First Home Buyers Assistance Scheme, which offers the first home buyer with full or partial stamp duty exemptions, which has now been topped up as a result of COVID until July 2021. So the reason why I say they're good target markets, because they've now increased that for full stamp duty exemption up to 800,000 on new properties with a reduced stamp duty up to $1 million. And then for existing properties, it's up to 800,000 in relation to partial exemption and 650 for full exemption on existing homes. If you are doing subdivisions, the block of lands, first home buyers can actually purchase a block of land up to $400,000 with zero stamp duty and a sliding scale up to 500,000. But on top of that, they also get a first home owners grant new home scheme, which is additional $10,000 for them if they're purchasing a new home or a new unit that no one has lived in. And also it can't be worth more than $750 at this point. But further that, they also get the home builder grants, which is an additional $25,000, which is making them even more attractive, especially to new units or new homes that are being built by hopefully you guys. But they also get a federal assistance in relation to a first home loan deposit scheme where the government, as of this year, has started to encourage the uplift in the market to try and push over, well, to encourage and stimulate the building economy by giving them funding, in a sense, as a guarantee to a bank up to 20%, as long as they've saved themselves 5%. So technically what that means is that if someone is purchasing a $500,000 home, if they've saved $45,000, the government will pretty much secure $55,000 of that for them towards their loan to get it to that 20%, so they don't have to pay the lender's mortgage insurance. So they're pretty much acting like a family guarantee, technically, the government. Look, I've always said that they're the people that really should be targeting out there for developers. They're the only real buyer who has the most incentives out there. And I would encourage you guys, if you have got your own sites, especially new units, to actually form some form of incentive towards first-time buyers. But talking about finance, I think we should go into George, noting the time as well.
Thanks, Eddie. So George Karam, Director of BF Money, specialises in property investment clients with complex legal and accounting structures and getting their funding through, which is great news for those entrepreneurs out there looking to do more deals in the future. Welcome, George. Let's make sure we get you unmuted, mate. Here we go.
Hi. And thank you for that, John. And thanks for everybody for your participation. Look, since the beginning of COVID, I think the finance game has been one of the more kind of the dynamic aspects of with the development and with the property market, in that there has been a real shift of appetite, a lot of changes within the policy, both of the bank and in the non-bank market. Banks are themselves very nervous about the outlook of kind of the property market, and then when you layer that with the aftermath of the Royal Commission, there's been about 4 separate investigations and reports into the conduct and into responsible lending. There's a whole host of new laws that are before the Parliament at the market, trying to tighten up responsible lending and trying to impose a best interest kind of like an obligation. And so, and while all of that is going on, banks have been under strain with their own staff and with their own kind of the resources, because they've had to divert those away to try and help with the people that have been affected throughout the COVID with their repayments or with their deferrals. So new applications are taking an incredibly long time. And here we're talking about for development loans, well, particularly the larger stuff, kind of with the multi-unit loans. And even in with the resi market, there are some of the banks had outsourced their home loan processing offshore. And since the COVID's kind of affected the entire world, in some of these places where they have outsourced those with the processing teams, people haven't been able to work from home, right? Because they haven't got internet. In some places, they haven't even got electricity at home. And so the loan, like with the processing times and the with the approval times, have just blown out for many of with the institutions. But overall, the banks are like they like to provide an umbrella to you when it isn't that actually raining. So in a market where getting pre-sales is very difficult, they'll ask for more. When it's very hard to show that your business has not been impacted too adversely by COVID, then they'll ask you to, or they'll want to lend to those, to the few rather than to the many. So development loans historically anyway take many months to push through, and in an environment at the moment where decisions and where kind of the knee jerking about the policy and about the appetite happens almost overnight, this is making it very difficult for anybody to give surety about what the loan is actually going to look like by the time it comes out. In some instances, we've been working on loans for a few months, and then overnight, a bank will turn around and say, look, well, we're going to suspend lending to new to bank style of clients. So it has been very interesting times. We've reworked, and sometimes reworked a lot of with the development loans that we have before us at the moment, and we've also done a lot of kind of with the rescue work, in that there were some loans where the bank had almost said to them, look, there's no reason why we won't, or we're not going to provide an approval. The developer has then engaged with the builder. The builder is on site, and then either there's been a massive delay in getting the finance through, or they've just withdrawn their interest completely. So you can imagine with the anxiety levels there. And if we are going to have a serious with a discussion about development loans, we now have to look at the non-bank market. And in the past, there was a lot of kind of with the stigma around, getting a development loan from a finance company. And I really understand a lot of the people's concerns there, because there are still the good, the bad, and the ugly. But overall, and particularly the last 4 or 5 years, what we have seen is a real sophistication of the non-bank market. You've got many more funds now than I've ever seen in the past. A lot of these are now either they're listed with the ASX, or they've actually got with their institutional style. For many of the larger multi-unit developments, a lot of the developers that we're working with will specifically say, look, please don't waste our time by going to a bank at the moment, only because of how long that they're actually taking. So the holding costs on these sites, even though that you are going to end up with a better product, with a cheaper loan product, by the time that you get it through, or by the time that they would discover some things about some of the sales that then they deem that they don't actually qualify, is just very expensive. But this also needs to be taken in a larger discussion with a lot of what Eddie, Bakous, and what Joe have been saying about the structures, and about getting your legal structures right. Because even though that development finance with the banks is actually taking a long time, there is a cost advantage in getting your money from the banks. So most of the work that we've been doing of late is to refinance, I guess, a lot of the long-term debt into very cheap loan products, and they're starting around the 2% at the moment, for lines of credit on commercial property, and on residual stock are in kind of the mid-2s to early 3%. So if your structure allows you to borrow from a bank, then you really need to consider that. But particularly when you have an asset that is an income producing asset, that then you need to make a monthly repayment on. With a development loan, it is a bit different. And it is different because there is a timeline, and there should be an exit strategy for that, or for that particular loan. So if you're going in, and if the feasibility allows for that extra finance cost, then you can be able to get into a loan a lot quicker, and you'll be able to get into it with a lower level of pre-sales, but you've still got to be able to mitigate the exits. And that is, okay, well, at what level of gearing do we need to at least have the pre-sales at, so that we can refinance whatever residual stock back into a bank, rather than, well, let's try and pre-sell all of the debt before we start, because that's now a very, very difficult thing to do. But the non-bank market is a very dynamic place at the moment. During April, May, June, we did see with the cost of that actually really peak, and now with the cost and with the availability of all of those funds starting to come back down, they're starting to be a lot more affordable and a lot more competitive. And I think Sydney is actually a beneficiary of the capital flows at the moment too, because a lot of these funds are saying, look, we really don't want to lend that much to Melbourne or to Victoria at the moment, and so they're making more and more money available in Sydney for developments and for developers. And this last month lockdown, we've really seen a return of appetite and a loosening of a lot of the terms and an improvement in a lot of the conditions. So that's basically where we're at the moment.
Thanks, George. Over to the panel now, and we've got a couple of key questions for the panel. Kicking off with you, Eddie, and then maybe Bakous. With the rising prices in Sydney and these challenges that George just highlighted to us, I wonder if syndicates are now perhaps the way to go. Eddie, what's been your experience with syndicates?
Okay, sorry. Yeah, thanks, John. Look, I've seen some of our participants who are here today, some of our clients who have been part of syndicates throughout the years. Look, syndicates, if no one's familiar with them, is generally when two or more people or companies get together to carry out a project, particularly on a joint venture basis. Look, it's a great opportunity for someone who wants to get involved in a development or purchase and doesn't have that big outlay that can do it. My personal feel is it's a good opportunity for people to join forces. Obviously, there's perks with syndicates as well, but if you are going to consider it, it's very, very important that you, prior to actually commencing any syndicate basis or projects or exchanging any contracts, if you're buying any properties, that you actually see your lawyer or accountant, one, to get your structure right, but two, to ensure that you've got your syndicate agreements in place, joint venture agreements, and also some deeds of petitions for stamp duty exemptions to be implemented at the beginning. I think it's a great way for, if you can pull together certain people to purchase sites. I mean, prices are high at the moment in Sydney, and we all know that. They are rising. I personally think that it's a good opportunity for people to invest as well. But they're my thoughts on it. It's highly recommended, though, you do get those agreements in place if you are looking at doing those.
And Bakous, I assume that not just the legal role, but there's a very important role that the accountants can play in helping the syndication process as well. Get you to unmute there. And
yes, John, that's correct. It's quite crucial to get the proper documentation in place. So if there's an interest in forming a syndicate, have the proper joint venture agreement in place. There's been countless situations where I've been called in to assist a particular joint venture party or a client, new client, where the actual agreement had holes in them, and the ATO then treated the agreement as a partnership. And as you know, with a partnership, there's a joint and several liability. So you could be liable for the construction costs, where you may be in a position where you've offered your home, which has been rezoned. You can't afford to develop the property on your own, so you hire a builder to come in and construct on your own land. And there's all sorts of issues down the track, whether it relates to tax or stamp duty, as it is covered through a deed of petition. So make sure the documentation is in place. Make sure it's a joint venture agreement. It doesn't form a partnership. so you're not falls in the foul rules of the ATO and having been exposed. So the structure is quite crucial, especially with the rising market in Sydney, but then again COVID-19 affecting sales.
Yeah, thanks. And George, I guess from a funding point of view, it's probably a lot easier to come over the top of a syndication for a final tranche of funding. It almost can replace, the syndication can replace those pre-sales that get the banks comfortable. I'm assuming that if a particular percentage of funding on a development was syndicated, it would be a lot easier for then you to get some traditional funding to cap that off on top. Is that correct?
Look, in some instances, sure, but at the moment, the banks just do not want to carry any of the market risk. But where we're finding the syndicates work is where you have the people that do come together. Some are asset rich and others are income rich, and then by marrying those two up, then like that, we can actually mitigate a lot of the risk and lower the cost of capital into the development. Syndicates, I think, more than any other thing, are ones that are very reliant upon getting the legal structures right. And one of the things that we like to advocate for with the syndicates is the inclusion of development management agreements. Those are very important tools and very powerful ways where we can use all of the strengths of the partners and all of the strengths of those that are actually contributing, to play to the strengths of a development, rather than having to deal with all of the risks that each of the parties might actually come and bring together. Those are they do take a bit of time to negotiate and to get everybody's head around, but once they are in place, and I think they actually add a great deal of value, tax, asset protection, but also the cost of capital, cost and the availability of kind of the capital. So you're able to tick a lot of the requirements off and a lot of the benefits off by using the one tool. But in order to get that right, you really need your accountant and your lawyer and your finance broker all to be working in sync towards the same goal. And once you do that, then I think then you get the full range of the benefits that each of us have been speaking about individually.
Yeah, well done. All right. Thanks for that, George. Now, we've got some bonus new laws here, Eddie. What's going on here?
Yeah, just thought we'd better add these in for this seminar, given that we've got a few developers and investors involved in this as well. These are two sets of laws that have come out this year to target certain defective workmanship by builders and also developers. The first one that you see on top there is the Residential Apartment Buildings Compliance and Enforcement Powers Act. It's called the RAB Act now. It commenced as of the 1st of September. This act is going to grant fair trading greater power to regulate developers during the construction and residential apartment buildings. The purpose of this act is to prevent serious defects being completed in an apartments. If you breach this, fair trading are definitely going to have more powers to actually issue you guys with building rectification orders and also prohibition and orders as well. And that's going to prevent you getting your occupation certificate. So it's very important that you be wary of that. You are also required now of the department. I'm hoping I'm not cutting out there, but you're required to give the department early completion notice, and that's about 6 to 12 months notice before completion of the project. Be wary of that, because they do have powers, the department, to actually issue stop work orders and also rectification orders, and also issue penalty notices to you as well. I won't go into too much detail on that act at the moment, but you know, if you have any questions, by all means, you can drop me an email. I'm happy to discuss with anybody. But the other act is the Design and Building Practitioners Act that commenced as of June this year. This act is just incorporating now a new statutory duty of care upon anyone who's involved in the building world, so including builders, architects, engineers, and any other workers in the industry. So Joe, watch out for that. You definitely have a duty as you would under your Home Building Act. The whole purpose of it, again, is just to prevent any kind of defects, people walking away from defects. You cannot delegate out of this power or this obligation. It does extend back now for 10 years as well under this act. And you need to be very careful, because what it generally means is that although you already owe this duty of care to people, you're definitely going to see a lot more litigation with respect to defects coming about, because the owners now have an easier way to establish that duty of care. So I will just go ahead now and book my holiday because that's about to happen, I think. So just, I think you should all just be very careful of that when you're moving forward with projects.
Another great example of why you're better off to have a good quality team of experts around you in your planning phase as well. Now, well done. Thank you, panel. We've got a special offer. We're about to go to the Q&A in just a moment. There's been some fantastic questions coming through in the chat box that you may have noticed. And so we'll be referring to those and addressing those as a panel in just a moment. Before we do, our team are going to drop an online form link into the chat box, which you can see an image of the form there. It doesn't really matter if you're a property developer, investor, other interest in syndicate or asset protection, or just want to reach out to any one of our expert panelists today and have a complimentary consult with any one of those. The way to do that and get your 15 to 30 minutes complimentary, absolutely no charge there, is simply to drop your form online by filling it in. So can we go to the chat box and just make sure it's in there now? Just have a look at your chat box. You'll see Lauren from our team has put in that link. You simply just click on that form, make sure you open it up in a separate browser, and that hyperlink should work for you there. I think I can bring it up on the screen. Emily, is that working on my screen? That yes, we can see that.
Yes, that's working.
Yeah, great. Thank you. So you can save that as a separate link there in the browser, and then we can come back to the Q&A. So our panelists are still ready to go. Sam, no problem. And thanks for your question earlier, Sam. Yes, this is recorded for your convenience as well, because you may have other colleagues in your property and development structures. All right, so let's go back into the Q&A now, shall we? So you've got your time there to fill out the form. No problem at all. And we will go back into the Q&A. So let's do that now. All right, fantastic. So from a little earlier on, the questions started rolling thick and fast. From around 1:47, yes, you're getting a copy there. Ruth, thanks for the feedback. We will assemble a Melbourne-based panel in the coming month or two. We'll get that organised. Thanks for pointing that out to us. Council's not happy about the code, Joseph. Yep, understood. The New South Wales construction grant for $25,000 from Sam, is this paid to the borrower or the construction company? Eddie, are you on top of that one? Let's get you to unmute. Thanks.
Yep. It's actually paid to the developer or to the builder, and they should be giving a credit back towards the purchaser or to the first-time buyer.
Thanks, Eddie. From Christopher and Joe, there's maybe a rolling dialogue there in the chat box. Christopher's question, what are the risks to developers with the new powers on hand to the building commissioner, and how can you overcome them?
Okay, I can sort of give you a quick rundown on that, Chris. You can buy me a coffee soon, Chris, and I can go through that with you. But just quickly, Chris, if they do issue you with a penalty notice, you have got, or a stop work order, you have got the right to appeal that to the Land Environment Court. Any penalty notices can also be dealt with through the local court as well, or the Land Environment Court.
Fantastic.
I hope that answers your question.
Thank you. And that coffee, well, that coffee is part of that 15 to 30 minutes, Eddie, isn't it? That we've got the
That's
form,
right.
and we will put the form back in towards the end as well, just as a reminder. We'll keep working through the questions at the moment. In terms of, from Gary's point of view there, sorry, I beg your pardon, Joseph next, SMSFs, can they invest into syndicates, SMSFs? I reckon this is for you, Bakous, isn't it?
Yes, definitely they can, but there are very strict requirements in relation to the SIS Act. There's so many rules that one needs to comply with, especially in relation to whether there's third parties or related parties involved. But that's a quite detailed response for that one.
Yeah, it is, isn't it? It's not just a simple one. And of course, the income cash flow planning, you've got to have some fair amount of prudence, don't you, Bakous, around a distribution back to the SMSF?
Yes, well, the trust can't make a distribution to a self-managed super fund. It can be by a unit trust structure. However, the investment strategy must allow for this sort of investments. Otherwise, the auditor one ticket of approval must be in that strategy. It must be allowed in the trust deed, the deed that the super fund's made of has to allow for that type of investment.
Yeah, and this next question from Gary in Queensland may be a combined response from Bakous and Eddie as well, I reckon. And Gary, you are a property accountant that I'm aware of in Brisbane. So how are syndicates and joint ventures handled from an accounting and tax reporting perspective? Is there a common ABN or tax file number for reporting in GST?
Oh, I can answer that, John. Effectively, in order to look at the proper structure and have the asset protection in place, and so that the ATAT doesn't also treat the joint venture as a partnership where you've got the joint and several liability, you need to set up a special purpose vehicle or a joint venture agreement in place and have a holding company that actually registers for GST, has its ABN not conflicted with the other related party entities, and have that as a separate vehicle together. So each party is responsible for their own, what they call output or profit, and their tax obligations.
Yeah, thank you. Joseph, the Commissioner is targeting defective workmanship, which is low-hanging fruit for the Commissioner, isn't it? Yes, we would love to see a couple of letters and some info about that, Joseph. So please do share that maybe with Eddie in the first instance, and our team will assist to distribute those case studies or those letter examples to the attendees today. Fantastic. Thanks, everyone. Now, Lauren's put the link back in there right at the bottom of the chat box. Joseph's got another tip there. Make sure weekly photos of site progress are done. They're targeting fire safety, sheeting, shafts, wet areas. You'll need as built drawings to be prepared as commissioners are comparing consistency between DA and CC approval. Again, interesting stuff. Thanks for your knowledge there being shared with us as well today, Joseph. Appreciate it. All right, that's terrific. Now, Lauren has just dropped in email addresses for all of our panelists today. You can see those. So the smart thing to do would be just to copy and paste. You can grab your mouse and copy and paste over those email and ID profiles there, and just drop them out onto your own. Send yourself an email with those in the body, or of course save them on the desktop on a notepad or a Word document. We are now, yes, that's right. There is a recording that will be sent by our team at Best Practice next week. Your recording of today's event will come from team@bpgrp.com.au. So when that comes out early next week, look out for that, knowing that that's not a spam email. That's our production HQ email there, team@bpgrp.com.au will provide you a link to the recording from today's event. And of course, we will also help to distribute with Eddie's support and the panelists further information and follow up as we've discussed today. So thank you to Eddie, George, Joe and Bakous. Fantastic contribution today. It's great to hear what's going on, and some of those golden nuggets there I think were unveiled today about some bona fide opportunities that you can take advantage of in the Sydney market. And no doubt Melbourne and Brisbane are looking forward to some information just like this, so we'll do some homework on that. But thank you again, Eddie. Well done to everyone for putting this on. The recording will be available no later than Monday night, 5 p.m. We'll get that distributed. So in the meantime, make sure you get that form. Lauren's put it in there. You can see that not far from the bottom of the chat box there. Get onto that form. Get your complimentary consulting opportunity with our panel of expert advisors here today. That is absolutely complimentary, and they can talk about your particular opportunities and aspirations there as well. You're welcome. Thank you everyone for attending. Have a fantastic Friday. And for all of us in lockdown in Melbourne, we'll just continue our slow pathway towards temporary insanity. We're in absolute denial. We're absolutely fine. Have a great weekend. See you later, everyone.
Happy Father's Day, all.
Yeah, good idea. Well done.
Bye-bye.
Okay.
See you guys.
See you later, all.